Right, good afternoon. It's Stephen and Tom again from Shepherds. We're going to be talking this afternoon on dealing with default in upstream joint operating agreements. As you might expect, Tom has done all the hard work here, so he'll carry the load of the talking, and I will chip in from the side every now and again. So we'll move on to the first slide.
Thanks, Stephen. Just if anyone has any questions, if you just use the chat function just whenever that question pops into your head, and we'll try and deal with them all at the end of the presentation. So just this slide, just on the agenda, what we're going to cover today. I'll have a brief look at the sort of license concession termination events in the event that one of the JOA parties defaults under the JOA, and then we'll move on to look at the JOA itself. So we'll have a canter through the JOA default processes and the typical provisions in relation to that, a quick look at operator default and how that's dealt with slightly differently, and then we'll discuss the enforcement risks around principally forfeiture or forced exit rights in relation to that, and then at the end we'll maybe try and draw everything together with some conclusions. So just dealing with license concession termination events, first, this obviously depends on the term of the license or underlying concession. Speaking generally, it's always difficult to speak generally. As parties have joint and several liability under licenses and concession, then a default under the JOA shouldn't necessarily cause a breach of the concession if the terms of the concession are being performed, which is probably what the non-defaulting parties will want. However, where you've got to watch out for a little is on insolvency termination events for a joint venture party, and the extent to which the insolvency of one of the parties can give the relevant regulator a right to terminate. Now, if you take the UK as an example, the UK used to have in licenses for rounds up until the 25th round just a general termination event in the event that one of the joint venture parties became insolvent, which obviously puts the OGA now in a difficult position in relation to that. There is now a partial revocation provision for licenses in the 25th round and onwards, which allows the regulator to terminate licenses for insolvency of just one party, or take them out of the license rather, but keep the license in existence for all of the solvent parties. And generally, what we've seen, at least in the UK context, is the OGA being sensible in relation to the insolvencies, the E&P insolvencies that have occurred recently, and being willing, I guess, to look at potential ways of managing that insolvency and ensuring that the license continues, and that in the case of exploration assets, that work is going to continue.
And not just, I suppose, in the insolvency scenario, because obviously the OGA is going to test financial capability and viability at various points through a UK CS license. And so where you've got, for example, an asset that's been matured up to the point of development, there can be sort of trickier issues arise around the financial capability and viability of joint venture parties going into an FID, FDP sanction position, because obviously there's a retest at that point as to whether or not the joint venturers have got the financial wherewithal to follow through with the development. Anyway, on to next slide.
So this is just a kind of high-level overview of the typical joint operating agreement default process. And I guess the philosophy behind the default provisions and the default process is really reflected in the fact that oil and gas joint ventures are high-risk and capital-intensive activities, and that it's fundamental from I guess a joint venture perspective and also a trust perspective that people pay their way, and really what the joint default provisions are intending to do is to try and provide some sort of deterrent to dissuade parties from allocating capital from more profitable projects without severe consequences, and to try to prevent people from cherry picking projects in which they honour their commitments when due and payable. So a typical joint operating agreement default process will start with default, and we'll come on to what that means in a moment. That will then result in the operator giving a default notice to the defaulting party and also to the non-defaulting parties. That notice will then result in an immediate suspension of certain rights under the JOA and immediate loss of any production that's coming through. And then there'll be a grace period, normally between 30 and 60 days following the issue of the default notice, before the forced exit rights are exercisable, and we'll come on to discuss all that in a moment.
And I guess just on that side, it's helpful to think that there might be an arrow just to the left of the default arrow, which is the kind of running of the joint venture prior to the event of default. Almost like Monopoly, before you get to pass go, you probably need to have done that first arrow correctly before you can be comfortable that you get into the execution of this default process, but we'll discuss that later.
So just on default itself, triggers for default, normally principally payment defaults. You would tend not to get other breaches or more general breaches of the JOA. The AIPN JOA has two additional breaches which trigger the default remedies or the default process, which is failure to provide or maintain any security that's required to be provided, so collateral for their obligations that's been agreed, and also non-performance of indemnity obligations, which in the AIPN pro forma will typically just be the anti-corruption indemnity obligations primarily. There's then in the UK oil and gas joint operating agreement and the decommissioning security agreement pro formas a cross default which will result effectively in an insolvency event default becoming a default for the purposes of the joint operating agreement as well. But a DSA would only tend to be put in place at the point at which you get an FDP or following that point. As I mentioned, the following a default, the operator will serve a default notice. That's normally non-discretionary, so the operator has to do it. That can cause issues in practice because sometimes operators do not, and the non-defaulting parties generally do not really want to get into a default process because, as we'll see, that has there are certain decisions that must be taken within certain periods of time in order to preserve rights in that process, and once you kick off the process you can't really stop it. One of the things, and one of the important things, is that the default notice triggers the non-defaulting parties' funding obligations, so their obligations to make up the share of the defaulted amount there, which again obviously has implications in certain scenarios for the non-defaulting parties.
And the interesting thing is, if an event of default does arise and the default notice is triggered, and when we move on to the next stage, you then have the effectively exit rights and become exercisable, which is really what Tom was alluding to earlier. If those aren't exercised, you're effectively abandoning the joint operation, which was the subject of the default, which is obviously why the service of the default notice starts in process a train that maybe none of the parties from the get-go really want, train of events that maybe none of the parties from the get-go really want to have happening, because they're then forced into making a decision either to step up and take the defaulting party's share of the joint operation, or to let the joint operation effectively be abandoned and lapse.
So just, sorry, on the previous slide,
Oops, sorry, my bad.
Cure rights, generally the defaulting party will have the right to cure their default by paying the defaulted amount plus an interest amount until the forced sale exit rights are exercised. But in some JOAs you can see that is pushed out until the actual transfers are completed and they lose their interest in, or part of their interest in the JOA as well. And then last point on this slide, repeated defaults. So I mentioned that payment defaults are the triggers. I guess what happens when a defaulting party cures a default in the default period and then subsequently defaults. In those circumstances, you can see how you might want to, I guess, accelerate the ability to exercise your forced exit rights in those circumstances. The way that that's dealt with in the Oil and Gas UK joint operating agreement is that if you're in default for a cumulative period of 60 days in any rolling 12-month period, then the forced exit rights become exercisable immediately. For the AIPN JOA, there's a kind of 12-month probationary period after the default's cured, and if there's a subsequent default in that probationary period, then the forced exit rights can be exercised 15 days after the exercise of the default notice rather than the standard 30. So, as I mentioned previously, the exercise of the default, or giving of the default notice, causes an immediate suspension of various rights under the joint operating agreement. That can often be the subject of negotiation. Typically it will be consent to data trades, consent to transfers of participating interests by non-defaulting parties, Ofcom voting rights, and matters requiring unanimous consent set out in the JOA, transfer of the defaulting party's participating interest, so you shouldn't be able to transfer a defaulted interest, and importantly information rights, and that I think has caused a slight problem in the practice for the recent defaults, in that if a party that is financially distressed is looking to do a marketing exercise of its share and is in default, the ability to provide potential buyers with up-to-date information can sometimes be lost as a result of this suspension of rights, especially if the non-defaulting parties insist on the enforcement of that suspension. There's also, as I said, an immediate loss of the right to take deduction on the service of a default notice. Interesting question arises as to what is production. Clearly, any production coming out the wellhead after the service of the default notice should cover that, but what happens, for example, in production that's come out of the wellhead that's in an FPSO that hasn't yet been lifted at the time that the default notice is served? No one really knows the answer to that. It will largely depend, I think, on an interpretation of the JOA and any lifting arrangements that are in place. JOAs will typically provide for a kind of waterfall relating to the application of any sale proceeds of production that the defaulting party would otherwise have been entitled to. So basically what will happen is the operator or the non-defaulting parties will sell that production and then apply the proceeds to firstly defaulted amounts, then any outstanding liabilities to post any security or make contributions under a decommissioning security agreement. And then in the context of the AIPN JOA, the creation of a reserve fund, which is a little bit of an odd provision. Effectively, it's to cover the defaulting party's share of the estimated costs of decommissioning or ceasing operations to the extent not covered in any decommissioning security arrangements. But I have to say the AIPN drafting is not entirely clear because that reserve fund is only created after the payment of the total amount that's in default with the proceeds of production, and that in itself should cure the default and end the default period. So a little bit of thought maybe needs to go into that if you're using an AIPN draft. And then, as I mentioned, if the default hasn't been cured in the relevant grace period, which is, as I mentioned, typically between 30 and 60 days after the default notice has been given, the forced exit rights become exercisable. And there's generally three forced exit rights, or types of forced exit rights that you'll typically see in a JOA. There's the total forfeiture or forced withdrawal rights, which you'll typically see in most JOAs. That is for no consideration. There's a withering interest type provision whereby the interest of the defaulting party is withered, and that an example of that sort of provision is in the AIPN draft. And how that works is that a percentage of the participating interest of the defaulting party is lost as a result of the default or the exercise of the default rights, and that percentage is equal effectively to the total share of the estimated development funding that's then outstanding, which hasn't been paid by the defaulting party. And you'll often see that that's uplifted by a risk factor that's set by reference to how far through the development we go. So you can see in an AIPN, in a withering interest provision, that the fair market value of the interest which is lost could exceed the amount of default. And the withering interest provision is intended to be a bit fairer because it's intended to give defaulting parties credit for development funding already provided, but it doesn't really give them the sort of fair market value return that they would see on, for example, a forced sale. There's also a slight gaming risk with the withering interest provisions in that the closer to completion of the development that you get, then the lower the interest that the defaulting party will lose, and so it might be willing to give up its share of that project if cash is limited and other projects are likely to be more profitable. So the third type of forced exit provision that you get is what is referred to there as a forced sale. So that's normally for fair market value with a discount, and seen recently discounts as high as 75%, which clearly brings issues with penalties. And the forced sales can be external or internal. An internal sale which allows the existing joint venture parties to buy out the defaulting party, or external, which is normally backed up with a security interest, which is basically the forced marketing and sale to a third party. Different JOAs provide for different arrangements in relation to the satisfaction of defaulted amounts, depending on the remedy, the forced exit remedy that has been exercised. So total forfeiture provisions generally will seek to preserve the defaulted amounts, mainly because those defaulted amounts may, if you're close to the end of a project and you're about to go into decommissioning, exceed and the liabilities for decommissioning are high, may exceed the value of the interest. Withering interest provisions generally satisfy the defaulted amounts, and then for the forced sales, then those defaulted amounts are deducted from the consideration payable. Say something about powers of attorney. In more recent JOAs, you will see powers of attorney in favour of the operator, which allow the operator to exercise rights or enter into agreements necessary for the defaulting party to effectively comply with its obligations under the forced exit provisions. If a defaulting party is insolvent, those powers of attorney are probably not going to be enforceable unless the relevant contractual forced exit rights are backed up with a security interest. And a security interest or cross-charge or security interest is something which you will often see in an AIPN JOA. It's, I think, in the Canadian joint venture, pro forma joint venture agreement, and also the Australian one, I think. And basically what those are is a security interest that's given by each joint venture party in favour of all of the other joint venture parties in security for its funding obligations. That can be a difficult issue or a difficult provision to implement properly, depending on the jurisdiction that you're in and the various perfection requirements that you have, and it can also cause problems for joint venture parties in terms of their funding obligation, their general funding arrangements, because a funder might wish to have some form of intercreditor agreement put in place in relation to those. So that's something to be aware of, and we'll come back to that at the end, I think. Stephen mentioned the potential for non-exercise of exit rights. I think in older JOAs, particularly in the UK, there's a provision which says that provides that if none of the parties exercise their the forfeiture rights or the forced exit rights, then everyone's deemed to have abandoned joint operations, and those are wound up, which is clearly not what people want to do, and that brings in, I guess, a difficulty in practice as to which arises whether or not you've got this deemed abandonment, which is actually what happens if a non-defaulting party doesn't want to pick up 100% of the interests of the defaulting party, because the way that the forced exit provisions will generally operate on a total forfeiture or forced sale is that the defaulting party has to decide whether it wants to exercise that right. It gives notice to the operator. It will take its pro rata share if everyone else decides that they want to exercise that right, but it will take more than its pro rata share of the defaulting party's interest in the event that it's fewer than all of the non-defaulting parties wish to do that. And that can obviously bring in risk, because you, in a project which is in development or in exploration, the non-defaulting parties don't really know how much of the cost and share they're going to have to pick up when exercising those rights, and that can in practice has to lead to a discussion between the non-defaulting parties as to what they're going to do.
Just on the kind of picking up on the power of attorney point on this slide, if you think through the practicalities of a defaulted joint venture, and we've ticked all the boxes, we've served our notices, and we got to the end of the 60-day cure period, and there hasn't been a remedy, and we're looking to forfeit the party in default out of the joint venture. In practical terms, for us to get their interest transferred to us and to get that transfer recognised by the OGA, we will need to have license assignments signed by the party in default. And if they're unwilling to sign the license assignment, which most of the time they will be, because otherwise we wouldn't be in a dispute with them, we're presented with quite a tricky challenge, because how do we get that interest transferred across to us? We have to traipse off into court to seek to litigate to get them to specifically perform the obligation to assign that would be in the JOA. And that raises a whole host of kind of second order problems that can arise at that point. So actually having that power of attorney in the JOA, and the draftings in the later versions of the UK form of JOA has got that power of attorney language to give you the enforcement security, if you will. Anyway, on to the next slide.
Okay, we'll quickly run through operator default. So operator default, certain additional considerations arise. You need to consider the operator removal provisions and when you can get rid of the operator, and the general provisions around the appointment of a successor operator. You need to consider who actually exercises the default rights and the management of the default process. Under the Oil and Gas UK JOA, it's the non-defaulting party with the largest percentage interest. Under AIPN JOA, it's any non-defaulting party, which can cause a bit of confusion. And then who operates during the default period, because ultimately if the operator is bust and hasn't paid, it's unlikely to be doing what it should be doing. This isn't really dealt with particularly satisfactory for fairly obvious reasons in any JOA, and in practice would be likely to be a bit of a mess. The AIPN JOA probably has a bit more detail in the sense that the operator manages the operations, presumably because it's the only person who is authorised to do it under the regulatory regime, but that the cash calls and receipts and invoices are paid into and issued out of the a separate joint account which is managed by one of the non-defaulting parties.
And quite often in a sort of operator default scenario, non-operators are going to be potentially quite reluctant to step into the operator's shoes, because generally there will have been a history of stuff going bad before the operator goes bust. And obviously anyone who steps into the operator's shoes on any of, for example, the procurement contracts or services agreements that may have been entered into is effectively stepping into the firing line that's been vacated by the insolvent operator.
Okay, so coming on to enforcement risks, there's two, I guess, types of enforcement risks that have traditionally been a concern in relation to forfeiture provisions. The first one is the general case law on penalty provisions, which if you've got a penalty, an obligation that's a penalty provision or is deemed to be a penalty provision by the court, then it's unenforceable. There is recent UK Supreme Court guidance on this, albeit not in the context of joint operating agreements. That test, as set out by the Supreme Court, is not whether the provision constitutes a genuine pre-estimate of loss, but instead is whether the provision is firstly a secondary obligation rather than a primary obligation, and if it is a secondary obligation, whether that secondary obligation is unconscionable or extravagant when compared to the interest which the non-defaulting party has in the performance of the primary obligation. So what do we mean by primary obligations and secondary obligations? Well, primary obligation is an obligation which, I guess, sets out the relationship between the parties and defines that relationship. A secondary obligation is an obligation which is triggered by a breach of the contract and really provides a remedy for that breach. You can have a debate in many circumstances as to whether or not an obligation is primary or secondary, and there's a fair amount of argument you can have about forced exit rights and the extent to which they're primary or secondary. I think probably the conclusion you come to is that there's a reasonably high likelihood that a total forfeiture provision is going to be classed as a secondary obligation, but the forced exit, forced sale rights, and perhaps the withering provisions are perhaps, there's more of an argument that they may be primary obligations. But as I mentioned, even if your obligation is secondary, it's not necessarily a penalty unless it's unconscionable or extravagant. The argument in the context of forced exit rights is that these oil and gas joint ventures depend on trust. It is defined to share risk in highly risky and capital-intensive activities. If a party defaults, then that inevitably leads to the breakdown of the trust, and therefore it's difficult to see why parties should have the option to take a reward out of the continuing funding of the project by the non-defaulting parties, but avoid all of the risks. So that would be the argument on secondary obligation. Probably Cavendish v. McDessie strengthens the argument that total forfeiture provisions are valid, albeit that there's not a UK case on those provisions specifically. relief against forfeiture is something which is often discussed in the context of penalty provisions. So even if you've got a forfeiture provision which is valid, it's not a penalty, the courts have said that they have equitable rights to grant relief against the consequences of that, so far as the non-defaulting party is concerned. Now, normally that's by giving the non-defaulting party additional time to pay, which in the context of a joint operating agreement is probably less of an issue, given that there's already going to be have been a significant grace period before you get to enforcement of the forced sale exit rights. There is sometimes some discussion and suggestion that the court might impose a requirement to pay consideration or require some kind of withering. That has never really been tested in court. I think it would be quite difficult to see how a court might, in practice, do that, because ultimately you would be at a point where those exit rights have been exercised, and the court is then forcing the non-defaulting parties to pay money over when they didn't expect to do so. So I think that's a difficult one to see that would happen in practice, albeit that there is some discussion, and in particular there was some discussion in Cavendish v. McDessie, which suggests that a court might try and impose some sort of relief on that basis.
I think just coming back to the point we discussed at the outset around having the running of the joint venture operating correctly ahead of the default event, when you get into enforcement of these provisions and enforcement of forced exit rights, effectively the perfect 20/20 hindsight is then applied to how the operator and others have run the joint venture ahead of the alleged event of default, because any party that's disputing that's in default is then going to be crawling over everything that's taken place ahead of the default notice to say, well, actually, I'm not in breach of this JOA. In fact, the fault lies elsewhere. I've not paid these cash calls because, for example, the service contracts weren't properly tendered and let, so this isn't a valid cash call. Or the form of the cash call or the AFE doesn't strictly comply with the accounting procedure, and therefore it's not been validly served upon me, or hasn't been served upon me in accordance with the budget, and so I'm disputing that. And so you then end up in the situation where you've got a party who isn't paying its share, other parties claiming that it's in default, it's saying it's not in default. What happens? You know, you've got the, if you will, the non-defaulting parties having to stump up their corner of the project costs without having certainty as to what the final outcome is going to be. You know, are they going to be able to pick up the defaulting party's share? It's all pretty unsatisfactory. And then if you add into that the time it will take to get a court hearing in the High Court, you know, you're looking at sort of 12 to 14 months possibly following the service of the default notice before you might get a full court hearing on it. And if you're going into a summary judgment hearing, which you would reasonably expect to get more quickly than that, maybe sort of 2 to 3 months, the smoke screen that a defaulting party can throw up at that point by simply saying, ah, well, I can't reconcile these cash calls back to the budget, and by the way, was this contract properly tendered? Should I be paying under it? That can be enough to put off the judge at a summary judgment hearing to say, well, actually, this is now going to be heard at a full hearing because I'm not in a position to say 100% definitively that you're in default. Anyway, on to the next slide.
So the other category of, I guess, enforcement risk relates to the application of insolvency law. And two principles mentioned there, the anti-deprivation and pari passu principle, which are slightly different. Those principles are basically applications of, they're common law applications of rules that derive from statute, and what they're intended to do is to prevent people from contracting out of insolvency law. So we take the anti-deprivation principle first. Basically, what that's trying to achieve is that when a party goes or a person goes into insolvency, that the assets that are on the balance sheet of the company as part of on it going into insolvency are available for creditors of the company. So it's seeking to avoid assets coming off the balance sheet to specific creditors upon insolvency. There's a recent case on it which set out the principles in quite some detail called Belmont Park. It's again a Supreme Court case. 2 points arising from this for current purposes. The first is that the anti-deprivation principle doesn't apply if the deprivation, i.e. the loss of the asset, isn't triggered by insolvency. Now, for many JOAs, that's not going to be the case, because what your default is a payment default. It's not an insolvency event of default. So that gives people more comfort there that the anti-deprivation principle probably wouldn't be applied by the court. The second point is, even if it is triggered or regarded as being triggered by insolvency, then provisions that are entered into in good faith and which have a genuine commercial purpose are valid, provided that they're not intended to evade the insolvency laws. So again, that's quite a useful provision, because what you're trying to do here is deal with the risk and reward on the basis and deal with the breakdown in trust, I guess, that's necessary in a joint venture agreement. And indeed, there is some older case law around that kind of situation where the courts are effectively saying, well, there's a genuine commercial purpose in exiting the arrangements that these parties are in.
And obviously the risk in the enforcement risk, if you will, here is that if a non-defaulting JOA party picks up the interest of a party in default and possibly agrees to pay a nominal amount or to pick up back costs that are defaulted, to what extent is that acquisition challengeable by an insolvency practitioner or subsequent insolvency practitioners having been effectively an acquisition of those assets out of the defaulted party's balance sheet at effectively an undervalue?
So the second insolvency principle is what's referred to there as the pari passu principle. So basically, this is a principle which seeks to impose the general principle of insolvency law that assets that are on the balance sheet as at the date of insolvency should be distributed to creditors on a pari or unsecured creditors on a pari passu basis. There's less case law around, or less modern case law around the pari passu principle, but I think it's clear that it's not necessary for the provision to be triggered by insolvency, which obviously increases the risk that it might be applied in the context of taking of production and forced exits. Some of the case law has discussed the extent to which the asset actually needs to, that's being not being distributed on a pari passu basis, actually needs to be an asset of the defaulting party when it goes into liquidation, or when the administrator decides to make a distribution, because of course administrations, in administrations, creditors are not necessarily going to receive distributions, and it's the distribution which triggers the imposition of the pari passu principle. How that works in relation to forfeitures of rights of production or the forced exit rights is a difficult one. I think it may be possible to argue that the right to production is effectively a conditional asset and therefore is in effect reassigned, and therefore the pari passu rule isn't applied. But I think that would require some sort of careful drafting, which probably isn't necessarily present in the current pro formas. it's probably more difficult to make that argument for the forced exit provisions as well. So I think probably out of the two, pari passu is probably the more difficult one at the moment, and probably the one where there's more uncertainty than the anti-deprivation principle. But ultimately, here, even if you get to forced exit rights in an insolvency situation, you're still going to have to force an insolvency practitioner to comply with the defaulting party's contractual obligations, which is likely to be difficult in practice, because those obligations are only contractual for the most part. And that really probably is the crux of the issue, which is actually you're probably going to have to do a deal with the insolvency practitioner, and the non-defaulting parties are arguably in a much better position to do that deal, because ultimately their consent is going to be necessary in the event that the insolvency practitioner wants to sell to a third party, and so they have some degree of commercial leverage in those discussions.
Tom, is it worth sort of mentioning some of the kind of slightly unusual structures that we've maybe seen more recently, where people have been actually planning for counterparty default in a way that is certainly would be unusual, I guess, in the UKCS around kind of trust arrangements and pledging of assets and escrow arrangements being put in place, or do you think that's too much?
So sure. So I think as a result of certain experience, this we haven't seen this in the UKCS, then there has been some discussion around what arrangements might be put in place in order to prevent or defaults, or make non-defaulting parties' rights on defaults more robust, and principally that has been dealt with through the cross-charging mechanism and the security interest mechanism I mentioned previously, and by effectively expanding those provisions so that rather than the security being security for the payment obligations, which would then allow the non-defaulting parties to exercise their security and sell the interest, by also making that security for the forced exit right provisions, in order to try to make those provisions more robust and provide more of, I guess, a defensive provision against a challenge by an insolvency practitioner. So, for example, if that security worked, then it probably wouldn't cause the pari passu principle to be capable of being applied, because a secured creditor or security is a recognised exception to the requirement to distribute assets pari passu. Those sorts of provisions still wouldn't, I think, get around the penalty risk, really, but they would largely deal with the insolvency risk if they could be put in place and more effective.
Thanks. So on to last slide.
So just wrapping up, I think given the enforcement risk and given the philosophy behind the forfeiture provisions and default provisions generally, there are commercial benefits in practice of providing a strong contractual remedy. In the insolvencies we've seen, or the default scenarios we've seen, actually people have in effect accepted that there's a strong likelihood that total forfeiture rights would be exercisable, and that has resulted in effectively a consensual deal being done either with the defaulting party or the insolvency practitioner in practice. As I mentioned, cross-charges and security interests will make rights more robust on an insolvency. We might see more of that kind of thought going on. It's not easy to put those in place in certain jurisdictions, including actually in the UK, and will take a bit of thought, but that might be something that people decide to put in place, for example, at the point at which an FDP is approved and the expenditure ramps up. Similarly, I think, and more generally, there's likely to be a greater consideration of what other areas of credit risk mitigation might be, or arrangements for credit risk mitigation might be put in place when parties acquire their interest in the assets. I think typically sometimes people don't consider that in any great detail. That really is your first opportunity to put in place credit risk mitigation arrangements. If you don't have that, then you can only really do it potentially at the point at which an FDP is approved, and then it's even more difficult to actually get what you want as well, because there's less of an incentive for the parties to give that. So that's probably the third conclusion. I guess picking up on a point Stephen mentioned, if you're going to exercise your default rights, you need to be clear that the payments for which have been defaulted on were actually due. That requires a consideration before you start to exercise them of whether the budgets were properly approved, whether the AFEs were properly approved, whether the cash calls were properly issued, and generally a consideration of the accounting procedure as well.
Thank you very much indeed, Tom. That was a rollicking roll through the world of JOA default and enforcement. If anyone's got any questions, I'm not sure we received any through the presentation, I'm happy to deal with those now. Or if you have got questions you want to deal with offline, the contact details are there on the screen now, so you can pick up with one or other of us, and we'll do our best to answer whatever queries you may have. So, seems no more questions. Well, I'll tell you what, we'll end the session there.
Okay.
Thank you all very much.
Thank you.